afternoon, everyone. Thank you for joining our talk today. We should be starting shortly. While you're waiting, I would like to share a short video to you.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Good afternoon, everyone. My name is Henry Poh. I'm an associate in Ma Wing Kwai, and I'll be the moderator for today's talk. The topic of our talk today will be Contempt of Court, forcing compliance with orders through committal proceedings. Before we start, let me give you guys a bit of an introduction to our firm. So our firm is called Ma Wing Kwai and Associates. We are trusted by SME, namely small medium enterprises, family businesses, and individuals. Our firm is established by Datuk Ma Wing Kwai in 1985, who is now the consultant of the firm. We are a medium-sized law firm with 32 lawyers and 34 staffs, and we have 4 departments, namely corporate, dispute resolution, employment, and individuals and families. We have also 5 practice groups, namely Asian China Desk, construction, foreign direct investment, real estate, and sports and esports. Our talk today is part of our MWKA online talks, which we hold quite often. The purpose of our online talks is to share knowledge, raise awareness, and to encourage networking. And this is particularly for our clients, potential clients, and in-house counsel. Our recent online talk was held on 11th of October this year. The topic was how to close up shop, dissolution, voluntary winding up, and striking off a company. And our upcoming talk will be on the 25th of October. The topic would be understanding damages for medical negligence, types, trends, and tactics. I'll now introduce you to the speakers of our talk today. Our first speaker would be Joseph Khor. He's an associate in our dispute resolution team. He also does corporate, employment, and industrial relation matters. Our second speaker would be Chieh. He is the partner of our dispute resolution department. I'll pass the floor to my associate, Joseph Khor.
Thanks, Henry. Welcome everyone to our talk this afternoon. We are very grateful for all of you who have taken time off your busy schedules to join us. Today, our topic will be on using contempt of court in the context of enforcement of judgments and orders. As everyone of us would be aware or would have some form of knowledge of how it works, when we go to court, we usually obtain a judgment or order in our favor. That's very common. Now, a lot of times, these judgments or orders by the court are not complied with. And this part of the talk is about enforcing a court order or court judgment by way of contempt, or more specifically, civil contempt. While yes, there are other means of enforcing a court judgment or order, sometimes contempt is necessary, as is a necessary measure and a necessary way of enforcing a judgment and order to ensure that they are complied with. And we will go through these points as we go through our talk this afternoon. In brief, we are going to talk about 4 points. I will be speaking on the first 2 points. namely what is contempt of court, to give everyone a brief overview of what contempt of court is. And then I will be talking about civil contempt as a form of enforcement of judgments or orders. And then after which I'll pass the floor to our resident expert, Mr. Chong Chieh, to share with everyone some case studies and tips, as well as the procedure for committal proceedings. Now you will see during this talk that we will use the word committal proceedings and contempt somewhat interchangeably, and we will make this clear why in a short while. But when you see these two words, just bear in mind that essentially they are similar, they're the same thing, all right? So let's move on. What is contempt of court? Now, contempt of court is somewhat a generic term, and it is explained by the court in Peguam Negara, Malaysia, or Attorney General against M. Kini.com, Sundaram Berhad, and another. Essentially, it is the power to punish for contempt. It flows from the existence of the court. The word raison d'etre there is a fancy word to say the existence of the court itself is to uphold the administration of justice. And it can never be said enough that the purpose of the law on contempt is not to protect the dignity of individual judges, as sometimes you read news articles, but it is in fact to protect the administration of justice itself. In another case, Zainul Zakaria against public prosecutor, the court states that the jurisdiction of the courts does not exist to protect the dignity of individual judges personally. It serves to protect the judiciary as the third arm of government rather than individual judges. This is just a basic introduction on what contempt is and why it exists, all right? Let's move on. And now I'll talk about the court's jurisdiction. Jurisdiction essentially talks about where does the court's power to hold someone in contempt flow from. Article 126 of the Federal Constitution provides that the Federal Court of Appeal or High Court has the power to punish any contempt of itself. This is similarly stated or provided for in Section 13 of the Courts of Judicature Act 1964. And so we might have a question. What about the Sessions and Magistrates Court? What about the lower courts or the subordinate courts? It also has power to take cognizance of contempt of court and to award punishment for the same. Although the punishment that can be meted out by subordinate courts is limited based on the third schedule of the Subordinate Courts Act, but still, the fact remains that even the subordinate courts, the Sessions Court and the Magistrates Court, has the power to punish contempt. Moving on, civil contempt as a form of enforcement. So some of you may be familiar with enforcement proceedings, that is proceedings filed after you get a judgment or order in your favor. And we'll look at how we use or where the civil contempt fall in the context of enforcement of judgments and orders. All right? First of all, there is a distinction between criminal and civil contempt. I will briefly go through this so that we are all clear on what civil contempt is, and we will focus on civil contempt in this context and how civil contempt that we are dealing with when it comes to enforcing judgments or orders in the civil law context. So between private parties and private parties, essentially. Criminal contempt is an act that threatens administration of justice by words or acts. So a lot of times when you read news articles recently about people making allegations against the judge, words spoken by, you may know, these all come under criminal contempt. All right, these are acts that threatens administration of justice by words or acts, essentially casting a bad light on the court. That is not the focus of our talk today. Our focus today is on civil contempt. Civil contempt involves disobedience of court judgments and orders. And it is this that we use in the context of enforcing judgments and orders to compel compliance. All right? In a recent decision by the Court of Appeal in Uttar Kumar against Abdul Wahab, the court says this: the purpose of civil contempt is to coerce the defendant to do the thing required by the order for the benefit of the complainant. The complainant in this case is the winning party, all right? The primary purpose of criminal contempt is to preserve the court's authority and to punish for disobedience of its orders. If it is for civil contempt, the punishment is remedial, meaning to repair the wrong that is being done, and for the benefit of the complainant or the winning party. But if it's for criminal contempt, the sentence is punitive to vindicate the authority of the court. So what can civil contempt enforce? We have put up a list here of different types of orders that can be enforced by way of civil contempt. Of course, there are other categories, but for the purposes of this talk, we'll be focusing on these because these relate mainly to enforcement of judgments. For example, if you get a judgment, an injunction is essentially an order saying that you cannot do this or you have to do this. For example, if I file a lawsuit for a land matter, for example, and I say that land belongs to me, and then the court decides that yes, the land belongs to me, the court orders the defendant to transfer the land to me. Or for example, restraining of meetings of companies. The court gave an injunction to prevent the company's officers from exercising certain functions or carrying out certain transactions. That's an injunction. Essentially, ordering someone to do something or preventing someone from doing something. That can also be somewhat what we usually watch in movies, something like a restraining order. That can also take the form of injunction. Or breach of undertaking. In the order, it says that I undertake to do something and I do not do it. The next one, disobeying a judgment or order to do an act within a time specified, similar to what I explained earlier. Or disobeying a judgment or order for delivery of goods within a specified time, that is on bailment disputes where there is a contesting of whether the goods should be delivered or not for whatever reason. Next, breach of orders for payment of monies under the Debtors Act, 1957. Some of us will be familiar with this and may have heard of the term judgment debtor summons. So judgment debtor summonses are filed under the Debtors Act as well as the rules of court. In certain situations, as we will come to explore later, contempt of court can be used if they disobey the order for payment of monies. We'll also touch briefly on aiding and abetting a breach of court order, as well as disobeying an order for security of costs, which is basically an order to say, put the money in the court first, pending the disposal of the dispute for whatever reason. So before I pass the floor to Mr. Gan, just wanted to highlight two categories with some uncertainties. First of all is enforcement of monetary judgments. If the judgment in your favor is for the losing party to pay you money, now this category has some uncertainties in the law. There are divergent decisions of the Court of Appeal on whether or not failure to comply with an order to pay monies can be enforced by way of contempt. All right? There's the decision in Hong Leong Bank which says you can't, and in the decision in Hong Kwee Siong which says you can. At the moment, the views are still divergent, and it is really up to the terms of the order itself to determine whether or not it can be enforced. So the High Court in BYD Auto Industry has decided that not every default in the payment of a monetary sum automatically gives rise to a remedy by way of an order for committal or contempt. Based on our analysis of the cases, it seems to be that the key factor is whether the monetary judgment has an order to do an act within a specific time frame. So if there is, the court would be slightly more willing to punish by way of contempt. The other category is breach of consent judgments or orders. Now, some of us who are familiar with litigation will know that sometimes parties reach a settlement in the middle of court proceedings or in the middle of a lawsuit, and they record this settlement by way of a consent judgment or consent order. The principle is that a consent judgment or consent order is not a judgment or order pronounced on its merits, but an agreement which incorporates the terms of the parties. So usually it's not open to contempt proceedings. So these courts have held that's the general rule. However, not all consent orders or judgments are bound to fail when it comes to committal proceedings. Generally speaking, where there is a penal notice or express term stating that failure to comply attracts contempt, then yes, there's a possibility of using contempt of court or committal proceedings as a way of enforcing it. So a penal notice is basically a notice at the end of your consent judgment or order, if parties decide to incorporate it, to say that if this order is not complied with, then the other party can be held for contempt. So usually it would be in the benefit of the winning party of the settlement to have such an order or a penal notice included in the consent judgment or order, so that you will open up the avenue for you to go for contempt if necessary and if the requirements are fulfilled, which will be explained later. The other way is to have well-defined and precisely worded or consent orders or judgments where there is an undertaking, or if the consent judgment or order is of a coercive nature, so you must do this within this amount of time. So in these two circumstances, the courts are slightly more willing to allow contempt or committal proceedings to proceed for breach of compliance with the consent judgment or order. Some other relevant considerations in pecunious judgment debtor or a judgment debtor who is in poverty, whether there are alternative remedies other than contempt, whether the contempt has been purged. So for example, you are supposed to do this within a specified period of time, you did not do it, but subsequently you have done it. Then you have purged your contempt. Or if it's an abuse of process, the court will not allow committal proceedings to be used as an abuse of process, and the court does not assist a person who comes with unclean hands. And that's tied into abuse of process as well. All right. I'll now pass the floor to our firm's partner, Mr. Gan, to elaborate on some case studies and tips as well as the procedure for committal proceedings.
Thank you, Joseph, for the insights. Also, thank you to Henry for the warm welcome. And very good afternoon to all participants, and thank you for taking your valuable time to attend today's talk. So I will just continue on case study and tips, and usually case studies and tips are supposed to be left at the end of the talk, but then as shared by Joseph on some points of matters that can be enforced by civil contempt. So I think it will be more appropriate now to actually analyze and to expand further on these matters. So just now, Joseph actually shared on breach of an injunction. So usually an injunction would either come in the form of interim or an interlocutory manner. The point here really is, even though it's interim and temporary in nature, any terms of injunction must be strictly observed, and refusal to do so will be punishable for contempt of court. And even though it's only temporary and interim in nature, they have the same effect as a final order. All right, so a person against whom an order of court has been issued is bound to obey the order even though it's nullity, until and unless it has been set aside. So even if the order that was obtained does not have logic or it goes against a very specific written law, that order that has been granted has to be complied, regardless how bad it is. So the only way is either to appeal against it or to set aside. So until and unless it has been set aside or appealed against, that order has to be complied. Then also, that's not every breach of terms of injunction is contempt. So in cases where the plaintiff, for example, does not manage to prove beyond reasonable doubt, or a particular act has not been sufficiently proved against the contemptor, then they cannot proceed, or the plaintiff cannot proceed with contempt. Like these 2 points as mentioned here, the court is unlikely to hold that a contempt has been committed until it has been proven beyond reasonable doubt, and that the contemptors or the alleged contemptors had proper notice of the terms of the injunction. And also it must have been sufficiently proven against the contemptor. So once the injunction has already been obtained, so technically the order has to be served on the defendant, so to speak. Once the order has been served or the injunction has been served on the defendants, that's when they have proper notice. If, for example, the contemptors then come to court to prove that no, they have not been served or they have no notice of such injunction, then it can be shown that the case has not been proven beyond reasonable doubt. Also on breach of an undertaking. So if a party has given an undertaking to court, then the party has to obey the undertaking given to the court. In this context, undertaking given by the applicant to the court, undertaking given to the court is an undertaking towards the court and is not an undertaking given to the defendant. Hence why if a party does not comply with an undertaking that has been given to court, that amounts to interference with administration of justice. Like what Joseph has shared earlier on to do certain acts within a specific time. Under Order 45, Rule 5 of the Rules of Court 2012, a judgment or order to do an act must be done within a specific time. If let's say a specific term of the order requires a certain act to be done within a specific time, and that particular defendant or the alleged contender doesn't comply with the order to do it within a specific time, there is a possible action in contempt. So the courts may extend the time specific, but there must be sufficient materials for the court to exercise their discretion. So let's say, for example, the court granted 21 days to perform certain act, and let's say the defendant couldn't perform the act within 21 days. The defendant then can actually apply to court to actually extend the time. But this is really dependent on the facts of the case, and there must be sufficient materials for the court to exercise such discretion. Next, also on delivery goods within a specific time. It's the same, where there is a judgment for delivery of goods within a specific time. It has been done within that specific time, failing which, then committal proceedings can be initiated against breach of orders for payment of monies under the Debtors Act 1957. So Section 4 of the Debtors Act 1957 provides for a contempt proceedings against judgment debtor, whereby proceedings on judgment debtor summons has already been commenced and the parties actually fail to comply with the order given in the judgment debtor summons. In a judgment debtor summons, it's usually where the court will order the judgment debtor or the defendant to come to court and perhaps make some orders in terms of payments. So there will be certain payments made perhaps by installments. So if let's say, for example, the judgment debtor failed to comply with the installments, so under Section 4, Sub 8 of the Debtors Act, the court may commit the judgment debtor to civil prison for failure to comply with an order for payment of the said installments. Also here on breach of orders for payment of monies under the Debtors Act, in Satapan against Lim Choi Hock, here where the judgment creditor applied for the judgment debtors to show cause why they should not be committed to prison for having willfully neglected to comply with an order to pay 2 installments of $100 each, which was due on May 1st and June 1st. So the learned judge held that the judgment debtors only earn an average of $2 to $3 profit per day for their living expenses by making cakes which are sold on the streets. So the judgment debtor had no means to pay $100 a month. So in this case, the considerations which Joseph have shared earlier, impecunious contemners. So this is a case where the judgment debtors, they are actually only making $2 to $3 profit. They don't have enough money actually to make a payment of 100 ringgit or $100 per month. Hence, in this case, they will not be found to be in contempt of court. Also on aiding and abetting a breach of the court order. For example, even though I'm not a party to the court order, but then I assisted the contemner to breach the order. The law of contempt is wide enough to cover a situation where I aided or abetted the contemner in breaching the so-called order. So in this Golden Star against Ling Pek Ho, just a summarized version of what actually has transpired. So the plaintiff here, the winning party, so to speak, obtained certain orders at the federal court. So the lawyer for the losing party then applied to review the decision of the federal court on 2 occasions. So the winning party, dissatisfied with the 2 review applications, then filed committal proceedings at the federal court and also at the high court. So the federal court held that the 2 review applications filed by the lawyers amounts to disobedience of the court order, and the lawyer was found to be in contempt for aiding and abetting the losing party. So next here, we will touch on the procedure of committal proceedings. So what do we really know about committal proceedings? And by knowing the procedure, what are the certain points that we have to take note when proceeding with committal proceedings in order to be successful in the committal proceedings? First of all, the standard of proof for both civil and criminal contempt is that of beyond reasonable doubt. As we all know, beyond reasonable doubt is the standard of proof in criminal cases. So regardless whether it's a civil or a criminal contempt, as long as it's a contempt procedure, the standard of proof is that of beyond reasonable doubt. The reason being, the ultimate end of a contempt proceeding is to bring or to imprison the so-called contemptor. Hence why the standard of proof is much higher than the civil standard of proof of balance of probability. So as shared by also Joseph on the jurisdiction. So the Superior Court's jurisdiction come from Article 126 and also Section 13 of the Courts of Judicature Act, whereby the High Court of Appeal and the Federal Court, they have the power to punish for contempt. And Order 52 Rules of Court technically spells out the procedure on how do parties or even the court proceed with contempt proceedings. So here are a few points to note by for parties actually trying to file in or initiate contempt proceedings. So failure to observe procedural rules and safeguards may result the application for committal being defective. Hence why procedural rules and safeguards must be complied with and must be followed to the T in order the committal proceedings not to be defective, because any failure to observe all these procedural rules or even safeguard may deem the committal proceedings to be fatal. However, not all procedural non-compliance will prove fatal. It will also depend on the circumstances of each case. Subsequently, in my slides, then I also will share a few of the cases where there have not been consistency by the court when it comes to allow or disallow the contempt proceedings. So if the contender is not prejudiced by the procedural non-observance, the defects are treated as irregularities and which will not be fatal to the contempt process. This was held by Society Jazz Hennessy against Wang Chang Senran Berhad. So the forum to initiate contempt proceedings is usually where the order of the court has already been granted. So for example, if the High Court granted us an order for payment of money within a certain time period or an injunction, then that is the forum for parties to actually initiate a contempt proceeding. So here where Muda trading against Phuket Piao, an application for an order of committal must be made at the court where the alleged contempt had been committed. So in Peguam Negara against mkini.com, which is a very famous case which also came out in newspaper. So in this case, the AG initiated committal proceedings against Malaysia Kini and also the editor-in-chief at the federal court because the third-party subscribers made comments against the CJ and the federal court. Hence why the AG then proceeded to initiate contempt proceedings at the federal court. Also in a case of PCP construction against lead modulation, what happened was at the Court of Appeal level, the dissenting judge made certain remarks against AIAC, which is the Asian Institute Arbitration Center, where the AIAC was not a party to the proceedings. So the AIAC then applied at the federal court. The matter then was appealed against, and AIAC then applied to the federal court to have the statements made by the dissenting judge to be removed. So a lawyer then made remarks against the so-called removal of the statements and also on the federal court. So the AG then in that case also then initiated contempt proceedings against the lawyer at the federal court. So here, when it comes to the procedure, so the first thing first, a formal notice to show cause has to be served on the alleged contemptor as to why he should not be committed to prison or to a fine. However, there have been inconsistency when it comes to whether a show cause notice has to be issued to the alleged contemptor. So in Tan Po Lee against Tan Boon Tian, the federal court held that a show cause notice which imposed penal consequences cannot be issued by a private litigant. So similarly, like our Ganeshi or some other form of applications, the show cause notice always be issued by the court, whereby, yes, of course, we prepared, but then there's a seal of court. So technically, the show cause notice has to be issued by the court. So in this case, in contempt proceedings, the federal court in Tan Po Lee is suggesting that the show cause notice shouldn't be issued by a private litigant. Whereas under Order 50, Rule 4, Sub 3, when the parties actually serve the documents, the Rule 2B is deemed to have been complied with. So therefore, the applicant here doesn't actually need to issue a separate and independent notice to show cause prior to the leave application. Similarly, in AG against the mkinney.com case, the federal court also held that the failure to issue the show cause required under 2B was not fatal or prejudicial because the respondent was fully aware of the AG's application. However, in the case of Nick Aisha, which followed the Court of Appeals decision in Muhammad Fauzi, held that the failure to serve a show cause notice is an irregularity and therefore render the committal application to be fatal. So contempt proceedings come in two stages. One is ex parte leave, and the other is the substantive hearing. So during the leave stage, parties will have, or the applicant will have to file a notice of application, which is supported by a statement. In the statement, the acts complained of or the grounds for the alleged contempt will have to be particularized. And here also in the statement, the name, the description, and the address of the alleged contemptor will all have to be stated. And the next document that will have to be filed will be the affidavit in support of verifying the facts. So technically, the statement is more important than the affidavit in support because the statement will basically contain everything, all the description, and also the grounds. And the affidavit is merely to verify whatever that has been stated in the statement. So once the court has granted an order for leave to proceed with the order of committal, then this order has to be drawn up by the applicant. So here, in these two cases, whereby the alleged contempt must be adequately described and particularized in the statement. So the alleged contempt or the acts of contempt must be stated in the statement. So if subsequently a party were to state everything in the, even let's say, for example, the written submission, it doesn't work. And that will be fatal to the contempt proceedings. Next is applicant must show or satisfy that there is a prima facie case of contempt to be successful at the leave stage. So here at the leave stage, all the applicant has to do is just to show a prima facie case. You do not need to show beyond reasonable doubt. So you just have to show that, yes, there is a potential case of contempt, the court is very likely to grant. And at the leave stage is an ex parte, so the court will only be listening to the applicant in the leave stage. So once the order or once we have passed the leave stage and the court has granted the leave, then we'll get to the substantive stage. So here what happens really, the applicant has 14 days to make an application for an order of committal, and the application must be made by way of a notice of application. So bear in mind, the 14 days here is time sensitive. The failure to comply with the 14 days will also render the contempt application to be fatal. So once the NOA has already been filed, the notice of application has already been filed, and there is a return date fixed on the so-called notice of application. So there must be at least 8 clear days between the service of the sealed application together with the documents referred to in Order 52 Rule 4. So basically the documents here will be the documents in your leave stage. So the order granting leave, the statement, and the affidavit, all will have to be served together with this notice of application to the alleged contemptor. If let's say on the particular date, the contemptor couldn't, for some reasons, the hearing date on the return date has been adjourned, then the applicant must then inform the contemptor that the hearing date has already been vacated and a new hearing date has been fixed. So when parties then attend the hearing proper or the substantive hearing, the hearing has to be heard in open court as provided for under Order 52 Rule 6. And the court should avoid making any order of committal without giving the alleged contemptor the opportunity to be heard. However, the court has the discretion to proceed with the proceedings is absentia if, let's say, for example, the alleged contemptor doesn't attend. So there are situations where the court can actually proceed with that. Let's say, for example, even after service has already been done, but then the alleged contemptor refused to attend. In such situation or instances, the court can actually proceed the proceedings in absentia. So what are the ingredients to prove? Here, again, you have to prove during the hearing, you have to prove it beyond reasonable doubt. There must be clear proof that the terms have been breached and the order have not been complied. The alleged contemptor must have proper notice of the terms of the order. So the order that we wish to enforce must have already been served. Once the service has been done, that's when the alleged contemptor is said to have proper notice. Also, the terms of the order must be clear and unambiguous. You cannot have a general term. It must be very specific and precise as to what you want the so-called defendant or even the alleged contemptor to do in the order that you wish to enforce. So here, the alleged contemptor then, let's say, has received the documents. He can actually then resist the so-called application. By resisting the application, the alleged contemptor will have to file in an affidavit in response together of the facts and ground. Why is he resisting? Alternatively, he could also file in, I wouldn't say this as an alternative argument. It really depends on whether he's attacking it on a procedural nature or he's attacking it on the facts. If he's attacking it on the procedural nature, he could also consider filing in a application to set aside the order granting leave. If the alleged contemptor is resisting on both facts and also procedure, then he should choose to file in by way of an affidavit in response. So here, the common ground for resisting for an order is usually procedural, meaning failure to comply with procedure. The other grounds are mainly derived from facts. So whether an applicant complied or failed to comply with the procedural safeguard or even the technical part of Order 52, it really depends on the facts of each case and also whether the non-compliance has caused prejudice or injustice to the contemptor. One of the point or procedural safeguard that the court usually will see will be personal service of the order that we wish to enforce. So here, in both these cases, where the court held that a copy of the order here, which we wish to enforce, was not personally served, then the order of committal or even the contempt proceedings will fail. So even though the plaintiff's counsel was present in court when the order was pronounced, that is not sufficient, as held by Capital Insurance. The failure to serve the order which the applicant wished to enforce, even though the plaintiff's counsel was present, it proves to be fatal. However, we also have what I've mentioned earlier on. We also have cases to say that where the service of the order we wish to enforce have not been served, there are also decisions to say that is not fatal to the contempt proceedings. So service on the firm of solicitors representing the defendant company was a proper service, even though the director was not personally served with the order. And also in case of J&J, the service of the access order is not essential, as the respondent husband and his solicitors knew of the terms of the access order. So here again, we can see a divergence of views by courts of different nature. I believe the nature and also the degree of the contempt is important when it comes to the courts, whether to uphold the contempt application or otherwise. So again, we have here the penal notice. So Order 45, Rule 7 states that the requirement for the endorsement of a penal notice on the order that we wish to enforce. So there are cases to say that penal notice is a prerequisite, and without a penal endorsement, it's fatal to the contempt proceedings. However, you have this case of Tiger Power Hits against Guinness Anchor Marketing. The court held that no endorsement of penal notice is not fatal as long as the alleged contender has knowledge of the terms. Also, in the case of J&J, there was no endorsement of penal notice. Justice Sutianju held that as long as there was knowledge, is sufficient. That being said, everything being said, contempt has always been held that to be used as a last resort. So the power to punish for contempt of court should be exercised sparingly, and committal proceedings should only be commenced as a remedy of last resort. And committal proceedings should not be exploited for tactical gains. For example, shouldn't be used for abuse of court. And technically, where there's an alternative remedy, then a party or the applicant should proceed with the alternative remedy before exercising the right to actually initiate contempt proceedings. So once contempt, the court actually grants the order of contempt or found the party or the alleged contemptor to be in contempt of court, then there will come a situation where there will be sentencing. So sentencing is just similar like our criminal case. So there will be mitigation, and then the court will decide whether to a sentence to prison, how many months in prison or days in prison, and then if a fine is necessary, then the court will also order for. So that comes to my end of my sharing. So we will take questions moving forward.
Thank you, Gan and Joseph, for the insights provided. We will now come to our Q&A session. First question that we have is civil contempt, meaning disobedience of court judgments and orders. What about displays of contempt for the court, such as rude behavior, outward rude remarks, or replies to judges or lawyers when being cross-examined, or disrespectful facial expressions, etc.? Would these constitute civil contempt? And if so, are they punishable acts?
Yes, maybe I can take this question. Behaviors in court, yes, it can constitute contempt. So these are contempts known as in facie contempt or ex facie contempt, meaning in front of the court or outside the court. So let's say, for example, we have a case of Hoslan Hussein against Majlis Agama, which is a case at the federal court. So I think this is a case to explain contemptuous behavior in court. The imam of the mosque, in this case, Hoslan here lost the case, an imam. So what he did was he took off his shoes and threw his shoes to the panel of judges at the federal court. So the federal court then initiated contempt proceedings and found him 1 year in jail. Yes, it depends on the degree also on the contemptuous act here. If you are going to say bad words, if you are going to point middle finger, for example, so these are situations where will attract contempt proceedings initiated by the court. Maybe if you will make faces, so to speak, perhaps what happens really, the court may just give a warning. But to answer the question, yes, situations like this can attract contempt proceedings initiated by the court on its own motion.
We will move on to the second question by Mohammed Shakib. If Company A obtains a judgment or order against Company B for debt owed, but Company B did not make good on the payment pursuant to the order, could Company A initiate committal proceedings against the directors of Company B under Debtors Act?
Okay, I will take this question. It really again, I think, okay, again, for debt owed, right? Again, the point is whether there is a specific timeline to actually make the so-called payment of the debt. If a failure to put in a specific timeline for the payment of the debt, my view is that you cannot proceed with contempt proceedings, because if just a debt owed and everybody starts using contempt proceedings, then there is no point having the other enforcement or execution proceedings. So it really depends whether there's a time period. If there's no time period, then I guess the ordinary execution proceedings will then follow through. I think there is one more question. Maybe I just address this. Can one say that the penal requirement under 45 Rule 7.4 does not apply for the contempt under Order 52? I think here really the point is that in order for you to proceed with contempt proceedings, you need to have the penal endorsement. So the penal endorsement is like a prerequisite in your order that you wish to enforce. Before then you proceed with, or at least initiate the contempt proceedings. The failure to have a penal endorsement on the so-called order that you wish to enforce, then there is a high chance that the contempt proceedings.
That will be the end of our Q&A today. Thank you, Gan and Joseph, for the insights provided today. Our upcoming talks, there's two. The first one will be the 5th of October on a Wednesday. The topic would be understanding damages for medical negligence, types, trends, and tactics. Our speaker for this topic will be Jeremy Balang, our senior associate, and Alicia Chin, our associate. The next talk will be on 8th of November, Wednesday as well. The topic would be an introduction to strata management bylaws. Our speakers for this topic would be John Chan and Jasmine Wee. Secondly, we would appreciate if you would fill up the feedback form. It will be posted in the chat box below. And also feel free to follow us on all of the social media platforms such as YouTube, Twitter, Instagram, LinkedIn, or Facebook, where we will be updating contents. Lastly, after this session, we do provide a 30-minute free consultation via telephone, video conference, whichever that is more convenient to you. That is all for today. Please fill in the form in our website. Link will be posted in the chat box. Thank you for joining us today, and we hope that you find today's session insightful. Hope to see you all in the next session. Thank you.
Thanks, everyone.
Yeah, thank you, everyone.